Sorry for the interruption. Yes. Okay. Okay, now Vijay. Good evening, everyone. So, in our previous classes, we discussed regarding the Negotiable Instruments Act. So, today we will start another important enactment in the syllabus for JCJ, that is the Indian Contract Act. So, Indian Contract Act, in fact, is the fundamental for all civil laws. So, if we keep aside the procedural laws, which is the Code of Civil Procedure 1908 and Indian Evidence Act, which applies even to both civil and criminal aspects of law, the Indian Contract Act is the most fundamental and basic law. It is also referred to by jurists and legal luminaries as the constitution of civil law. Okay, so all civil laws are following the fundamentals and the basic structure that is provided by the Indian Contract Act. So, Indian Contract Act cannot be ignored, it cannot be sidelined by any new laws which are coming in the recent times. So, you may take subsequent enactments like the Information Technology Act or Transfer of Property Act, or you may take Consumer Protection Act or other transactions which are taking place online like the Electronic Commerce, or you can take even the Arbitration Act to that matter, Arbitration and Conciliation Act. So, or particular laws which are dealing with labor laws, so which are dealing with employment, service rules. So, all are in them having the fundamentals of Indian Contract Act. So, it is very essential either to flourish in the judicial profession as a judge or in the legal profession to have a very comprehensive understanding of the Indian Contract Act. Now, when we look at the background of the Indian Contract Act, we can understand that it is a pre-independence enactment. So, Indian Contract Act is in 1872. So, before India's independence, during the British regime itself, the Indian Contract Act was enacted. Similarly, earlier the Indian Evidence Act was also there in the same manner. Okay, or to that matter, even CPC, IPC, these are all pre-independence enactments. So, that is why we find the word Indian here. So, because the English have made this law for India, as such it contains the word Indian Contract Act. In recent enactments, apart from the BNS, BNSS and BSA, which have been recently enacted, which contain the word Bharatiya in it, so other enactments do not have the word Indian. If you see any other recent legislations, you have the DPDP Act or the Data Protection and Data Privacy Act. So there is generally we don't find the word Indian in it. Probably now we will see the trend Bharatiya being included. We don't know what will happen. Now coming to the Indian Contract Act. So first of all, what is law of contract, or what do you mean by, or what is its scope, what does it include, what does it cover, what does it regulate? So, the law of contract deals with all kinds of mercantile transactions. So, all transactions which take place in the, which are of commercial nature or even non-commercial nature, but which take place in our daily usage, in our day-to-day activities, everything is governed or comes under the scope of Indian Contract Act. So, law of contract deals with law relating to general principles of contract. It is the most important part of mercantile law, and it affects every person in one way or the other, as all of us enter into some kind of contract every day. So, from the time, just like how we refer that your law is actually regulating each and every individual from cradle to grave, you can see the presence of Indian Contract Act also. From the time you wake up in the morning till the time you sleep. So from the as soon as you wake up in the morning, what do you do generally? So there is some place where you sleep. So it is some house, there is electricity, there is fan or AC, there is bed. So everything you have purchased somewhere, right? So all these transactions of purchase, you become the owner of it, you purchase it. So you purchase it for certain amount of money. So it is again there is involvement of the contract. So you are entering into a contract to purchase certain articles. So then you wake up, you brush your teeth, the paste you use, the toothbrush you use, everything there is contract around it. Then you are working somewhere, you go to your job. So there is service contract. So if you are doing some job as in some software company, so there is some employment contract that is there, that they need to pay certain amount of money as salary to you. Or if you are doing business, so there are so many transactions, contracts that you have with your customers, with your employees, right? So and the shop that you have, whether you are taking it on rent or whether you are purchasing it, again there is a contract. Okay, then again till the time you sleep, the food you are eating, you purchase it somewhere, or the cook you have at your house, the servant, the maid you have, again there is a contract. So contracts can be oral or written. It is not that contract only means that it should be written, it should be signed, it should be stamped, it should be registered. These are the additional requirements which are imposed upon some special forms of contracts. But in spirit, the contract can be either oral or written. Okay, so we will be dealing with all those different circumstances as to what is valid contract and what is void agreement. So if you look at the Indian Contract Act, it is an act to define and amend certain parts of law relating to contracts. So the Indian Contract Act itself, in its full title, it itself clarifies that it is not the comprehensive legislation dealing with all aspects of the contract. It clearly states that it define and amend certain parts of law relating to contracts. So it says it is not dealing with all types of contracts, and however it is dealing with certain types of contracts, and particularly the general principles of contract. Okay, and it came into force on 1st day of September 1872. Now if you look at the scheme of the enactment, that's how you need to study any act, right? So in the scheme you will find that the first 6 chapters of Indian Contract Act, they deal with general principles of the law of contract, and remaining chapters refer to particular contracts, so which are arising out of like ordinary transactions in by merchants and traders, like you have bailment, pledge, agency, guarantee, indemnity. So these are special contracts which commonly take place in the merchant world, or where the merchants and traders are regularly involved in such type of contracts. So because they are very common in their occurrence, there has to be certain basic fundamental principles which have to be followed in respect of these special contracts, so that other chapters deal with those. They have identified certain types of contracts, and the essentials and other aspects of those special contracts are discussed in remaining chapters. So earlier, initially, the Act also included chapter 7 on sale of goods. Sale of goods is where sale of movable property. So but subsequently we have separate enactment now. We have the Sale of Goods Act 1930. There was also a chapter on partnership in the Indian Contract Act itself. The last chapter was on partnership, but subsequently in 1932 then we have a separate enactment now on the Indian Partnership Act. Okay, so now it is essential that we focus on the general principles of contract first, and then we will go to special contracts. So we will not be going into the provision or the Indian Sale of Goods Act and Indian Partnership Act as of now. Okay. Now let us look at the scheme of the enactment. So what are the different chapters and what each chapter deals with, what are the provisions. So if you see the provisions under the Indian Contract Act, you have sections 1 to 75 which are dealing with the basic general principles of the contract. Okay, and here again you have chapter 7 which is repealed, then sections 124 to 238 which deals with special contracts relating to indemnity, guarantee, bailment and agency. So here in bailment even you have a pledge that is covered, pawn or pawnee is also mentioned there. Okay, so these are the special contracts. So now as what each provision deals with and what it states, by you need to be very clear about it. Okay, and also if time permits and if you are really interested on the civil practice or want to excel in the judicial service examinations, you need to know the sections by heart. So it's not a very big enactment, it is very concisely drafted. At least if you don't know the entire provision by heart, the entire section by heart, at least which section deals with what. So that can be done based on chapters. So if something is coming in chapter 6, let us suppose, if it is section 74, then you need to know that it deals with breach of contract. Or if it is coming, if the section is 52, then it is something relating to performance of the contract. Okay, so now the preliminary is section 1 and section 2. Section 1 speaks about short title, extent, application, etc. And section 2 deals with the interpretation clause. So we will be looking into that in detail. Some important definitions are given under section 2. And then in chapter 1, we deal with communication, acceptance and revocation of proposals. So proposals and offers are one and the same. So the word proposal is used in the Indian Contract Act. So when the communication of proposal is complete, when the communication of acceptance is complete, as against the proposer, as against the acceptor. Okay, those, and when revocation, communication of revocation is complete. So these are very important aspects, particularly when the mode of communication is through post, which takes time. So once it is put into communication, once it is posted, it takes time for it to reach the opposite party. Okay, so then when the communication would be complete, once it is posted or once it is received. So those things are very critical to understand. So you have the mailbox rule, which is applicable to the postal communication, and then with respect to instantaneous communication over telephone, over mobile phone or instant messaging services. So there this mailbox rule may not apply. Then, pardon? Electronic communication is there. You have emails, WhatsApp messages. So these are instantaneous. So there is not much time is lost when communication is done, right? So immediately it will be received by the opposite party. Immediately response will be received by you. Similarly, in telephone communication, there is no gap. So you are speaking something and immediately he is receiving and the other person is answering. So now there may be some unique circumstances that may arise. Like for example, there is some disturbance in the telephone line. Okay, some disturbance is there, some technical disturbance is there, it is not so clear. And you ordered, let us say you said, I want 1000 pencils or 1000 pencil boxes for your school, let us suppose. So, and the other person heard that you want 10,000. So he understood it is 10,000. Then whether you will be liable or not. Right. So those are interesting circumstances that may arise. Then you have chapter 2, which deals with contracts, voidable contracts and void agreements. So contracts here means valid contract. So what are the essentials of a valid contract? So like section 10 particularly speaks about it. We will be dealing with that in detail with respect to majority of parties, acceptance, unequivocal acceptance, consideration, etc. are there. Then you have voidable contracts. So voidable contracts are another type of contract where the contract may be rendered void by one of the parties. So one of the parties has the option to choose whether he wants to follow the contract or treat it as a void agreement or render the contract void. So particularly when the consent in the contract is not free, when there are vitiating elements of consent which are present in a contract. So there is a list of those elements like misrepresentation, fraud, undue influence, coercion, mistake. So when these are present, the contract may be rendered void by the affected party. Now I told you an example. So there is a mistake. So he said okay, but he said okay thinking that it is 1,000 pencils, not 10,000 pencils. So there is a mistake of fact. So there may be mistake of fact, mistake of law. Then what would be the consequence? Those things are provided under chapter 2. Then you have contingent contracts in chapter 3. So what do you mean by contingent? Contingent means which is dependent upon happening or non-happening of a future uncertain event. Okay, so like if you marry, I will give you 1 lakh rupees. Okay, or if you are able to deliver this particular goods. Okay, I have a contract with a tailor, let us suppose. So before the festival,